Good morning, everyone. On behalf of my entire team of students of Maharashtra National Law University, Mumbai, MA Executive Degree Program in Mediation and Conflict Resolution, I welcome you all to this session of the Meet the Mediator program with well-known mediator from California, USA, Mr. Jeff Kichaven. I, Poonam Makhijani, will be moderator for this session. And apart from being a student of MNLU MA program Mediation and Conflict Resolution, I'm practicing advocate mainly under Consumer Protection Act from last 21 years. Before starting today's event, I offer my respect to our gurus of MNLU MA program by chanting Gurur Brahma, Gurur Vishnu, Gurur Devo Maheshwara, Guru Sakshat Parabrahma, Tasmai Shri Guruve Namaha. So to start with, now I'll invite Preeti Walimbe to provide a brief introduction of this program. Preeti is practicing advocate at the Mumbai High Court from more than 15 years. And she is also the candidate with our program on MA Mediation and Conflict Resolution. Yes, over to Preeti, please.
Thank you, Poonam. Good morning, everyone. I am Preeti Walimbe. I take this opportunity to welcome you all for the session of Meet the Mediator series conducted by candidates of the MA Mediation program. Firstly, I would like to share with you all something about our university and the master's program which we all have enrolled for. Maharashtra National Law University, Mumbai was established in the year 2014. It is one of the most premier universities of India. Mr. Jeff, I take immense pride in informing you and everyone here that the Honorable Chief Justice of India, Mr. Sharad Arvind Bobde, is the Chancellor of our university. Our university imparts legal education by nurturing equity, ethics, and inclusiveness. It encourages service to society and lifelong learning. I'm sure everyone over here will agree with me that currently there is a scenario where there is a mounting pressure on the judiciary to adjudicate the disputes, whereas there is an urge in every litigant that dispute should be resolved at a very quick space. Under this in this context, no one can underestimate the importance of mediation. I am delighted to inform you all that in this context, our university had set up several centers which encourages mediation and research. CMR means Center for Mediation and Research is one of such centers. It was set up in January 2019 under the leadership of Ms. Tanu Mehta, who is also director of our master's course. I am further delighted to inform you all that under the stewardship of our Vice Chancellor, VC UK, we have developed this MA Executive Program in Mediation and Conflict Resolution. It is India's first such postgraduate degree program in mediation, which hopes to set the standards of mediation study and education across the country. The program is running in second semester. I once again welcome you all to this series and I'm confident that this will be a very informative session. Over to you, Poonam, again. Thank you.
Thanks, Preeti. I'd like to invite now Madam Shobha to give a brief introduction to our guest mediator, Mr. Jeff Kichaven. Madam Shobha is a Director of Placements at NMIMS University, Mumbai, and is also a master candidate of our Mediation and Conflict Resolution degree program. Yes, Madam, over to you.
Thanks,
Shobha, Madam.
Yeah, thanks, Poonam, for the introductions. A very good morning to everyone from India and good evening to our guest mediator, Mr. Jeff Kichaven. It gives me great pleasure and honor to invite an esteemed mediator, Mr. Jeff Kichaven, for the Meet the Mediator series. Jeff is a Harvard Law School alumnus and an associate bachelor in economics from the University of California, Berkeley. Jeff is an independent mediator of business disputes with an international online practice. In his practice of around 40 years, he has led various law firms and appeared before the courts. He has also over 20 years of experience as a mediator. He was associated as a mediator with JAMS and with professional mediation and arbitration. He has been practicing as an independent mediator since 2009. Jeff has held several positions at various bar associations in California, USA. He is a distinguished fellow and past member of Board of Governors at the International Academy of Mediators. He teaches mediation at various institutions, including the Harvard Law School, the Pepperdine University School of Law, and the American Law Institute. Jeff has received many honors and awards. Some of them are Best Lawyers, Best Mediation Lawyer in Los Angeles in the year 2015, Roy H. Aaron Award, Outstanding Board Member by the Center for Civic Mediation of LA County Bar Association in 2012, Special Award for Excellence in Mediation by the Asian Pacific American Dispute Resolution Center in 2010, the Instructor Masterclass for Mediation Award from Harvard Law School in 2007, California Lawyer Attorney of the Year Award in ADR in 2006. He is ranked in Chambers USA list of the country's top mediators for the past 3 years and the Who's Who Legal Global Elite Thought Leader in Mediation. Jeff is also a mediator of the Global Mediation Panel and the Office of the Ombudsman for UN funds and programs. His specialties include the areas of insurance, intellectual property, information technology, professional liability, employment, trust, and estates. I take this opportunity to welcome Jeff for this session of the Meet the Mediator program. Thank you.
Thank you all so much. I'm delighted.
Thank you, Shobha ji.
I'm delighted to be here. So many thanks to all my new friends at Maharashtra National Law University. I've been to India twice. I've been to Mumbai, where you're located, and you can see my souvenir elephants behind me on my bookshelf. I love India. I love the Indian people. Can't wait to get back, and I'm just so happy to be here in conversation with all of you. Thank you.
Thanks, Shobha ji. Thanks, Jeff. Dear participants, please be informed to you all that interview will be carried into 2 parts. Before we proceed with the actual interview session, I would like to share some house rules for all participants. All participants are requested to keep their camera switched off and mic off throughout this session. Any questions from participant can be shared in the chat box, and if the time permits, we will take up those questions towards the end of the session. Now, to begin with the first part of the interview, I like to invite Mr. Mohamed Humdhan, an arbitrator, adjudicator, and a chartered surveyor from Tamil Nadu, based in Brunei, with over 25 years of experience in construction industry, who is also a master candidate of this mediation program. Yes, Humdhanji, over to you.
Thanks, Poonam. Good evening, Jeff. On behalf of MNLU Mumbai and our first batch of master's degree program, our sincere thanks to you for sparing your valuable time for this session. We are honored by your presence here. From Shobha's introduction, I see that you have a very impressive professional history that starts since 1980. You had spent over 20 years on legal practice before initiating a career on mediation. Can you also please share with us what initiated this change in your career from a legal practitioner to an independent mediator?
Humdhan, thank you so much for having me here. I'm delighted to be in conversation with you. And thank you for asking about what made me decide to become a mediator. So I graduated from law school in 1980, as you mentioned, and I was one of the youngest members of my law school class. I was 23 years old when I graduated from law school. And when I began, I was kind of a bookworm, you know, went to all these fancy schools and just studied all the time. And when I became a litigator, it allowed me to give vent to a different side of my personality, much more aggressive side of my personality, because many times that's what's called for in hard-fought, high-stakes commercial litigation. And when I was in my 20s, I thought it was fun to behave in this aggressive way. And I didn't know there was a different way to be a litigator. Now I know that there are different ways to be litigators. But at that time, that was the culture in which I found myself. In any case, as I got older and hopefully more mature and got married and had children, the idea of the round the clock pace of being a litigator and the stresses of being a litigator, I just wasn't enjoying it as much anymore. And around that time, in the mid-late 1990s, the mid-1990s, mediation was coming into its own as a career that you could actually have, particularly as a career that you could have if being a judge. In California at that time, before there were such things as mediators, there were such things as rent-a-judges. That's what we called them, rent-a-judge. And you would rent a judge to do a settlement conference, not really what we would call mediation, but it helped people get cases settled, and it can be a valuable service in many instances. But anyway, mediation was coming into its own as a thing you could actually do for a living. And I was really just in the right place at the right time. I took some mediation training, initially not intending to be a mediator, but intending to learn how to be a better negotiator representing clients in the mediation process. But in the role plays, I would try to avoid having to play the role of the mediator in the mediation trainings, but sometimes you had to, you couldn't avoid it forever. All right, I would play the role of the mediator. And it was okay. And the law firm where I was practicing encouraged us to do pro bono activities. So I started to do some mediations for free through different court annexed programs, and I kind of liked it. And then people were starting to call back that they actually wanted to hire me and pay me money to be a mediator. Well, this was good. And around that time, I left the law firm where I was practicing, a larger firm, and I went into a very small firm with a couple of friends. And I was doing more and more mediation, and it was obvious that I was happier on the days when I was serving as a mediator than on the days when I was serving as a litigator. And one of my then law partners became a judge. He is still serving with great distinction as a federal judge here in Los Angeles, Dean Pragerson, a wonderful man in all regards. And when Dean took the bench, there I was. I was not the rainmaker. I was not the one bringing in business. I knew that I could keep working on Dean's cases for a time, but they would either settle or they'd go away one way or the other. And then what was I going to do for a living? I had 3 small kids. I was married. I had to do something. And I thought that I thought I could make it as a mediator. I thought my personality was better suited for it. I thought I could figure out how to market myself to lawyers more easily than I could figure out how to market myself to business and industry, which frankly, I never figured out as well as I thought I would be able to figure out. And as I say, Humdhan, I was in the right place at the right time. Around 1996, I decided to do it full time, and I've never looked back. It's been one of the best choices I've ever made in my life to become a professional mediator.
Thanks, Jeff. That's really very inspiring. Your views actually reflect some of our cohorts in the course who
Yes.
are senior mediators as well. Some of them are fresh graduates who have just joined. So your early views that during the early part of your career that you wanted to make a shift because of your view towards this adversarial approach is also being reflected by our young lawyers who have joined this course. Thanks for that. And we have a diverse set of candidates in this course. They come from a variety of backgrounds, the like of surveying, construction, accountancy, etc. They are all keen to know how important law plays in the practice of mediation. And what is your reflections on this?
Then let's talk about the importance of legal training to be a mediator. So I have 2 answers. One is it's not important. The other answer is it's extremely important. So let me explain why. We have programs here in the United States where we teach teenagers what we call peer mediation, student to student mediation, so that they can help to resolve conflicts among their fellow students in middle school, high school. And these are kids who are 14, 15, up to about 18 years old. And some of them are really good mediators. So when people ask me, do you need a law license to be a good mediator, to be an excellent mediator? I say, no, you don't even need a driver's license to be a really good mediator. You can learn the skills. At the same time, to mediate in the what I would call the commercial marketplace, to mediate litigated cases that are pending in the court system, you have to know a lot about how litigation operates. Are there people who are not lawyers, who have never gone to law school, who have learned enough so that they can be outstanding mediators? Yes, absolutely. My friend Lee J. Berman here in California, Cliff Hendler in Toronto, many others. Those are just two outstanding mediators who come to mind. Cliff was in the insurance industry. Lee J. was in the real estate development industry. But along the way, they learned a lot, so that if they were to sit for an exam in a subject such as civil procedure or evidence, they would do very well on those law school exams if they were to take them today. And there are a couple of reasons why it's important. You have clients who think they've done nothing wrong and that they either should have to pay nothing or get a lot in settlement of a lawsuit typically. And their lawyers are telling them, nope, that's not likely to happen. What explains that? What explains the gap between the client's belief that they should get this fantastic result and the lawyer's advice to them that the fantastic result is not likely and maybe they should lower their expectations? Well, what explains it typically is the way the litigation system works, the laws of procedure and the laws of evidence. And so those, I think, are the most important areas of law for a mediator to know. Other things, patent law, real estate, products liability, whatever, you can learn that. We have a little joke in the United States. You know the difference between a beginner and an expert in any area of law. You know what it is, Humdhan? 48 hours. And so bright people can figure it out pretty quickly. So that's one reason that legal training is necessary. The other reason that people who have been lawyers may find it easier to succeed is that a lot of what we do in mediation has to do with the relationship between lawyers and their own clients. Sometimes there are serious rifts in those relationships, and a lawyer and client have communication breakdowns. The lawyer's advice is not getting through to the client. There may be emotional intensity to it that's difficult for a lawyer to deal with. And people who have been lawyers, who have been in that chair, who have walked a mile in those shoes, are sensitive to those things and can pick up more easily when that's what's really going on. This lawyer needs help with the attorney-client relationship. And if you're not familiar, if you haven't suffered through some of those bad relationships with clients yourself, it's an element of background that you're lacking to be what I think is a truly outstanding mediator in the context of litigated cases. You can pick it up, but it's hard.
Thanks, Jeff. That is really very insightful insight for all our candidates here and attendees. Based on your vast experience in mediation, what are the skills that are essential for mediators? If I ask you to choose the top 3 as a priority skill among them, what would be? And please share with us your reasons for choosing them.
Thanks for asking about skills, Humdhan. They really don't have much to do with law. The first one is patience. A mediator must be patient because people come into mediations expecting certain outcomes. And those outcomes are not reasonably possible to achieve. And we have to draw people in to outcomes that actually can be achieved. And people come to that at their own pace. You cannot look at people, you take people at 9 in the morning when they show up for the mediation, and they think that they have everything going for them in the case, and you think the case is a much closer case. If you just tell them, oh, by the way, you're wrong, the case is not so clear cut, let me tell you why, 1, 2, 3, that's not likely to be effective, because the clients, the people who in the disputes, they know that as good a person as you may be as a mediator and as smart as you may be, you're not their lawyer. You don't owe them a duty of undivided loyalty. You're not their advocate. You're the person who's there at some level to see a deal get done. And all else equal, you would rather see a deal get done than not. So what we say in those regards very often is discounted, because who are we? Who are we to tell people they're wrong at 9 o'clock in the morning after they've had these entrenched beliefs for sometimes years at a time? That's why I would say skill number 2, you have to understand the mediation process and how to manage and curate and choreograph the system of communication and the system of conversations in order to get people to come to their own conclusions. Oh, I didn't really understand the way I understand now that it's 4 o'clock in the afternoon, or 6 o'clock at night, or 2 o'clock the next morning. I think I understand why my lawyer has been telling me for the last many months that perhaps my expectations should be tempered. So we have patience. We have an understanding of the mediation process and the skills of communication. And we also have to develop a certain sense of empathy for people, and that they're, it's tough for them. It's tough for them. We're sitting there as a mediator. Today it's this case, tomorrow it's the next case. We have to step back and remember the humanity of the situation, that these are real people with real tough situations. People don't go to lawyers casually to file lawsuits. So the fact that you're in a lawsuit means that what's going on is pretty important in these people's lives. And you have to develop, you could call it empathy, you could call it some sort of emotional intelligence. There's a lot of names for it, but it's not something they teach you in law school. In fact, it's something that many would say they drum out of you in law school, right? In law school, it's just plaintiff versus, P was driving above the speed limit, or, D was driving above the speed limit and runs into P's car in an intersection. And sometimes they're just P and D. The people don't even get names in law school, right? P for plaintiff, D for defendant, the red car and the blue car. So in law school, when we're learning cases and principles of law, we try to get at a higher level of abstraction to learn what are the legal principles which are applied equally: equal justice under the law, equal justice for the rich and poor, equal justice for everyone in society. That's our goal. So we have to get ever higher and higher levels of abstraction in law school. When we're mediating, we understand those cases and principles and the legal concepts. Then we have to bring it back down to the human level as well. And it's learning all of that and integrating all of that that is essential, I think, to effective mediation.
Thanks, Jeff. I definitely concur with you. As an arbitrator and adjudicator, these skills are also very important in order for us to make the process successful. Jeff, you teach in some of the world's famous institutions on negotiation and mediation programs. What is your reflection on pedagogy you usually adopt for these programs? And how does that differ when these programs shift from face-to-face to online?
Oh, Humdhan, everything is different now that it's online. Everything is different, and yet everything is the same too. So last spring, a year ago, when the world shut down because of the pandemic, we all had to learn a lot very fast about how to use Zoom, how to manipulate those breakout rooms. We had to learn other online platforms as well, because it's not just Zoom. Some people like Microsoft Teams, and some people like WebEx, and some people like Blue Jeans, and some people, there's new ones being invented all the time. So it's really the concept of mediating online. And to a remarkable extent, we've gotten used to it, haven't we? We've spent so much time online that now it's almost like talking on the telephone. When we talk on the telephone, we can have very personal, very intimate conversations, very intense conversations, because we were brought up talking on the telephone. It's no big deal to us. So now we've had to learn very fast to adapt to Zoom and the other online platforms. And to a large extent, we have, so that the communication is really, has gotten pretty good. There are some things where I do notice a difference. And one of the big differences is that people are not in the Coliseum-like environment of a law office anymore. You think about it, I'm wearing a shirt and tie, but I'm also wearing blue jeans and sneakers. And you may be too, Humdhan. And a lot of people are, you know, they're dressed one way from the waist up and one way from the waist down when they're online. They're in their homes. Their dog or cat may be around, their children, their spouse, their familiar environments. It's very different than the Coliseum-like environment of the law office. When you come to the law office, we're wearing our not only shirt and tie, but the whole blue suit, fancy, you know, socks and uncomfortable shoes. And you drive to a special place, the mediator's office or some law office typically. You park your car and then you go up the elevator. And for so many people, that ride up the elevator, whether it's to the second floor or the 50th floor or the 100th floor, it doesn't matter. That's a very stressful elevator ride, because in that elevator ride, people's stomachs are knotted up because it reactivates all the stresses and all the tensions and all the unhappiness that led people to the litigation situation in which they find themselves. When people are at home and they've got their snacks there and their dog is sitting next to them or their cat jumps on the keyboard, whatever, it's all different. So I find we're able to have more direct communication, less shuttle diplomacy as a percentage of time in the mediation, and more opening joint sessions. In the United States, people have gotten away from opening joint sessions. Many people have. I still try to have them whenever appropriate, which is much of the time. But they can become antagonistic. And when you're in the Coliseum environment of the law office, it's easier for people to become antagonistic. And when you're in the comfort of your own home, many times the people who are doing the speaking are less antagonistic when they're speaking. And the people who are listening, it's not as easy to get them antagonized when they're in the comfort of their own home. They're not going to start yelling and swearing with their children listening, or at least fewer people are going to start yelling and swearing with their children listening. The presence of a dog or cat can be helpful too in that regard. You know, who wants your dog giving you a funny look? So we're able to have more direct communication. That's one big change. And in order to get that direct communication going, the mediator's preparation is critical. Because if you just come to a mediation, if you just read people's mediation briefs or statements, they come to a mediation, the plaintiff's group is here, the defense group is here, and you as mediator turn to the lawyers and say, oh, okay, now what do you think and what do you think? What are lawyers going to do? They're going to do what they know how to do, which is giving the kind of antagonizing, sometimes strident, sometimes bombastic, vigorous advocacy, opening statement that they might give in a courtroom or an arbitration. That has a pretty good likelihood of antagonizing people, setting the mediation process back or derailing it altogether. So as mediator, what I like to do, and I think is an increasing best practice here in the United States and perhaps in India too, after I get the mediation briefs and read them and think about them, I like to call the lawyers and find out what else is going on. Talk about some of those personality issues. No lawyer is ever going to put in writing, I'm having difficulty in my relationship with my own client. Nobody's going to put that in writing. But if that's what's going on, we need to know about it. Our chances of addressing it and addressing it effectively are much greater if we know that that's part of what's going on. I ask people what their expectations are of me. What are the biggest challenges we have to face? I may ask other questions. And I'll almost always ask about process. What about an opening session? What might the agenda be? Because there are some issues which may be more appropriate for an opening session than others. So for example, let's say the key issue in the case is the measure of damages. And I'm sure you have these basic measures in India as we have here. Out-of-pocket rule, benefit of the bargain, right? It's that way everywhere in our cultures. So let's say the issue is, does the out-of-pocket rule of damages apply or the benefit of the bargain rule? That's a pretty good topic for joint communication because it doesn't really implicate the conduct of the parties. It's just law stuff, right? But it may explain why people can't come together. A bad topic to get together, to discuss together is, for example, in the law of fraud, the concept of scienter or intent to defraud. Were you just mistaken or were you really intending to deceive me? That's a very bad thing, I think, to discuss all together because it's personal, it's moral, right? It's ethical. Are you a bad person who would deceive me? Ooh, try to stay away from that. So try to find out, are there some, I call them more antiseptic issues that you can discuss together, and then limit the joint session to those issues so that in mediation trainings, we often called it a plenary session, meaning it's open to everything. Well, a plenary session may not be such a good idea because if you let lawyers put anything and everything on the table, it may get too antagonistic. So you can limit the joint session in terms of time, in terms of agenda, figure out in advance who's going to speak. When you meet with people at the beginning of the day, you might meet with the side separately, make sure everybody's kind of calm enough to have an opening session. And you might say, Mr. or Ms. Client, what are your thoughts about participating actively in the opening session? What might you say? What might you not say? Lawyers are often reluctant to have their clients participate actively out of a reasonable concern that the client may say something wrong or dangerous. So if you have an opportunity to rehearse it, the chance of the client saying something counterproductive goes down. And also when you rehearse it in private before you go into the joint session, some of the emotional steam is let out so that when it's discussed the second time in the joint session, the emotional intensity tends to go down. Couple that with the online environment where the emotional intensity is reduced a little bit anyway, and you can have more of that joint session communication. Where does it really pay off? It really pays off then if you go into caucusing with the sides after that joint session. Because let's say, Humdhan, that we go into a caucus. I say, Humdhan, we were in that joint session and Poonam made 3 points in terms of her support of the benefit of the bargain measure of damages, point 1, point 2, point 3. What did you think of Poonam's point 1? I didn't think that one was very good, but number 2, that one made sense. What do you think of that? So now you and I are having a discussion of what Poonam said in the presence of your client. With any luck, it will have some persuasive impact on your client that maybe Poonam's points really made a lot of sense. And maybe this sure thing is actually a closer case than your client actually thought. But let's say we don't have that joint session. Let's say we just go into a caucus and I say, Humdhan, I understand you're arguing in favor of the out-of-pocket measure of damages. Well, you know, the other side, Poonam, they're arguing for the benefit of the bargain measure of damages. And I've got Poonam's brief in my hands, and I say, now Poonam's got 3 points in favor of benefit of the bargain. Number 1, what do you think of number 1? Number 2 is that the case of Hadley versus Baxendale claims thus and so. How can you distinguish Hadley versus Baxendale? This Humdhan does not look so much like a conversation as it looks like an argument. It looks like I'm arguing Poonam's side for her rather than just having a conversation with you about what Poonam had to say in the joint session. Anytime it starts to look like an argument, it's bad news. Because if it looks like a mediator is arguing with a lawyer, virtually always the mediator is going to lose that argument. Because in the eyes of the client, again, you are the one with the duty of undivided loyalty. And the mediator is just the person there who'd rather see a deal than no deal. So the client's almost always going to believe you over what the mediator has to say. You're the one with the client's best interests at heart. So that's kind of a long-winded explanation of some basic mediation principles, how they operate in the online environment. And one of the key distinctions, Humdhan, in concluding this topic, what is the real difference between good mediation and bad mediation? One of the distinctions is this. In good mediation, the mediator helps the lawyers do a better job of negotiating for their clients. In a bad mediation, the mediator negotiates for you. That's a key distinction to keep in mind. And there are ways we can use the online environment to our advantage in doing that.
Thanks, Jeff. This is really very informative for aspiring mediators. Thanks for patiently answering all my questions. Certainly, I have learned a lot from your answers, and I'm sure the attendees as well. So I would hand over back to Poonam for the second session. Thank you. Thanks, Jeff.
Humdhan, thank you for these excellent questions.
Great.
It's wonderful to be in this conversation with you. Thank you.
Great. Thanks, Jeff. Thanks, Humdhan. Now we are entering the second part of the interview, for which I'd like to invite Madam Shilpasharad Shrikande for the interviewing Jeff. Shilpa is a peace peddler, ADR, ODR practitioner, and a panel mediator with the Bangalore Mediation Center and other notable institutions over 25 years of experience. Shilpa is also a candidate in our master program. Shilpa ji, over to you, please.
Thank you, Poonam, and thank you, Humdhan, for that wonderful start. Good evening, Jeff, and good morning, India. I have to thank you, Jeff, for your valuable time that you are spending here with us. So I would like to...
Thank you for your valuable time.
Thank you. So first, I would like to start with, do you feel the mediators need to have understanding of culture and cultural background of participants in order to be the better facilitator? Did you feel that while mediating in Mumbai and New York or in LA?
It's not, yes, it's important, and it's not that difficult to figure out enough. You know, 20 years ago, people would talk about cross-cultural mediations, and it was really talking about points of etiquette. How do you hold someone's business card when they hand it to you? And are you allowed to cross your legs in a way that somebody sees the soles of your shoes? And there's a lot to remember, frankly, about all the different people. So what I find in my experience is that if you as the mediator are coming across as being sincerely interested in helping people, and you really care about the people, and you're curious about them, then the people with whom you're dealing will be very forgiving of minor breaches of etiquette. And the important thing is really the spirit that the mediator brings to it. Okay, the mediator's from another country. They don't know our ways. The mediator's not trying to insult us or offend us. This is just how the mediator, this must be how they do it in California. No, whatever. I think that patience, the first virtue or skill that I discussed with Humdhan, is important because some people, some people like to negotiate slower. Some people like to negotiate faster. Some people are intentionally vague in making commitments. Some people are very specific and want everybody to make rock solid commitments to positions, progress in negotiations. So being patient and learning what are these, what's good for them, what's natural for them, with what are they comfortable. And then also remembering the key distinction between good mediation, bad mediation. You're helping them negotiate better for themselves. Now, as mediator in a cross-cultural situation, you might say to somebody in a mediation, they don't seem to be responding well to the fact that you're going so fast or going so slow, or they don't seem to be responding well to this or that. What do you think about that? And what can we do about that? Because we're generally dealing with people of some degree, high degree of maturity and self-awareness, and people who are capable not just of behaving one way, but of adapting, right? We all adapt to people in different cultures and learning to be, patient about things. Poonam began the session tonight with a chant of gratitude and devotion. That's not something one would commonly see in the United States. Just wouldn't see it. And I admit the first couple of times I saw something like that on my first trip to India, I was taken a little aback by it. And I thought, oh, this is very different than anything we would typically see in the United States, but that's all right. This is how people do it in India, and it's beautiful. And I'm going to go with it, And even in talking with people, I spoke with many lawyers in India, realizing that they have some different, they're just differences. And being patient and remembering that we're all here for the same purpose, to see if there's any reasonably possible way to settle the case. We all have some degree of adaptability. And those are the things that I think are important.
Thank you, Jeff. Now I want to, since you have said the good mediation, bad mediation, I want to understand one more thing, that success of mediation is not determined by arriving at settlement, correct? So if that is so, then I would like to know from you, what are the possible reasons for the mediation not reaching a settlement?
Oh, there are so many reasons why a mediation may not reach a settlement. There are different reasons in every case that does not. One thing to keep in mind, Shilpa, is there's a time element to it. Why hasn't the case settled that day? And I think every one of us, I would venture to bet, if a case doesn't settle, on the way home, we beat ourselves up terribly. Why didn't I say that? Why didn't I think to say that? And even worse is, why did I say that? Right?
Absolutely.
So we think these things. Sometimes, though, the parties are just not ready to settle. As I mentioned earlier, they've had their way of thinking for months and maybe years about the case and how it should come out and how they think it's going to come out. And at the mediation, we want them to consider possibilities that are different, sometimes very different, about how a case is going to turn out. Well, that can take some time, right? It may not happen by 5 o'clock at night. So sometimes people need time for new realities to sink in, to think about new approaches, to adopt new ways of thinking about the situation, and that can all take time. So one thing that I would advise mediators is don't beat yourself up too hard, because whether it seems like a simple case or a complex case, I think in the United States, mediators will tell you that every year fewer and fewer cases settle on the day of the mediation. So that leads to follow-up, and you have to follow up. On my calendar, anytime a case doesn't settle, I'll say, well, when would be a good time to follow up? And I'll follow up either by email or telephone call, whatever seems appropriate. How's it going? Any new possibilities for settlement? Can I do some things to help? And very rarely do people tell me to stop. People generally appreciate follow-up from a mediator. And of course, I don't charge for those relatively short follow-up calls. Nobody's going to pay you for an unsolicited telephone call, so don't even think about it. What you want to do is, from a business standpoint, you want to impress on people your diligence and how much you care about them, and you want them to become your good, steady, repeat client. So one way to do that is with diligent follow-up. And I find that usually, almost always, when I do follow up, I'm able, in my own mind, I think I have some positive impact, positive influence on the case ultimately coming to a settlement.
Thank you for that wonderful explanation. Now I have one more question for you. Many feel that mediator, it's a mandatory pre-litigation mediation, which is upcoming in India as well. But in certain countries, it is already there, pre-litigation mediation, which is mandatory. But it opposes to the basic principle of mediation, that is voluntary nature, correct? So what is your view on that?
Ordering people, my experience is that when courts order people to mediation, you do sometimes settle a case. I think it's less likely to settle when people are ordered to be there. The United States, people know, lawyers, sophisticated lawyers know what mediation is. They don't have to have a court. 25 years ago, maybe somebody had to tell them. And 25 years ago, maybe a court had to order people into mediation. I think the time for that in the United States has long since passed. When people are just revving up to get a lawsuit filed, they're usually very angry. They're just girding themselves emotionally for the prospect of being in litigation. If a lawyer says to them, or a mediator says to them, you really should consider paying a little more, taking a little less, you get it behind you, you don't have to have distraction from your other business and professional pursuits, or distractions from your family life, you save money, there's all these good things about settlement. Well, if it's a fresh wound to these clients, I want to kill him. He ruined my business, or he stole money, or he infringed my copyright, or he wrecked my car, that so-and-so. People are not really in a mood to hear, well, you really should consider pay a little more, take a little less. It's not going to go anywhere, So when is the right time to settle a case? The right time to settle a case does not depend that much on the factual state of the record. It depends on the emotional state of the parties. When are they ready to turn the page and make it not a fresh wound, but part of ancient history? Sometimes I think of it this way, and we've all lost loved ones, perhaps parents, perhaps grandparents. And how long does it take to grieve for the loss of a parent or a grandparent? Well, it's different for different people. Some people, after a relatively short time, are back to their business. Some people, unfortunately, for months or even years, have a hard time. They may need to go see a therapist, or get some help or whatever. This is kind of the same thing with litigation. When is the right time to put it behind you? When is the right time to say to a client, look, now is the time, pay a little more, take a little less, get it behind you. It's different for different people. And the ones who know best are the lawyers involved, because the lawyers are the ones who are close to the clients, who can sense the client's emotional state, who are the ones who are the worst to make that decision. By and large, I think judges, because judges, they don't know the clients. The judges don't, how many judges say, why don't we have your client talk for a while so I get a sense of your client's mood and emotional state? There's not a judge in the world. I shouldn't say the world, but there's not because I don't know the whole world, but I'm not aware of a judge anywhere who's interested in spending scarce time on that. When mediation is just getting introduced into a culture, I can understand that there's some reason for some prescribed period of time early in the development of mediation in a legal culture in a particular jurisdiction, when there does have to be, maybe not ordering, but at least encouragement. A judge could order lawyers to meet and confer about the advisability of mediation. That way, a lawyer could sincerely go to their client if the client is reluctant and say, look, I think the judge really wants us to mediate. If we don't have a mediation, the judge may be unhappy. Let's do it. That's usually a true statement. So it gives lawyers a way of not looking weak in the eyes of their clients if judges order people to meet and confer. And it also gives lawyers the possibility of saying, look, this is just not the right time. My client is not ready to put this behind them. Ultimately, the ones in the best positions to decide who is when to mediate, and also who the mediator should be, because there's no one mediator who is right for every case. There may be, you can look at where a mediator went to school and did they practice with a prominent law firm and have they done hundreds of trials and did they write a book, a legal treatise on the subject? That's all helpful, I suppose. What's more helpful is to ask yourself, will this mediator be able to get on wavelength with my client? Will this mediator be able to help? Who's having trouble communicating in this case? Maybe I, the lawyer, am having trouble communicating with the other lawyer. Maybe I, the lawyer, am having trouble communicating with my own client on the same side of the table. Who's having trouble communicating with whom? And who's the mediator who's going to be able to get on wavelength with us in order to help us communicate with each other better? And that's something, again, that a lawyer is in a good position to decide. And the judge, where's a judge going to get that information?
Yes. Thank you, Jeff. That was really great. Now, a question is for students. Okay, from all the students, this one goes for you. That we are always taught that opening statement is crucial for mediation process. Is it possible to conduct mediation without opening statement?
Sure. I mean, yes. And sometimes for good reasons and sometimes for bad reasons. Sometimes the lawyer doesn't have the skill to manage an opening statement, opening session properly. That's a bad reason not to have an opening session. When lawyers screen mediators, one question should be, are you comfortable when it's appropriate having and managing effectively an opening session? It would be, we have, for example, a procedural device in the United States, the motion for summary judgment. You have those motions when there's no disputed issue of fact, a judge can terminate a lawsuit without trial. So it's called in the United States a motion for summary judgment. Could you imagine going to a lawyer and the lawyer saying, well, I just don't do motions for summary judgment. They usually don't work. They cost a lot of money. Judges rarely grant them. We just don't do them. Nobody would hire such a lawyer. Why would somebody hire a mediator who says, look, I don't do opening sessions. people just get mad at each other. They never work. I don't know. It doesn't work. I just cut them out altogether. No, a mediator has to have the skill to manage some level of emotionality in an opening session. Now, there still may be some good reasons not to have an opening session and where everybody gets together. And that may be, for example, in cases where the emotional intensity is just so high that the lawyers tell you, look, my client just hates that person so badly. If they are forced to set eyes on that person, they'll break out into a sweat and they'll get hives and a stomach ache and a migraine, and it's going to be terrible. Well, if a lawyer gives you that advice, then to force it is not good either. I'm reminded from a yoga book I read, what's the difference between a true guru and a false guru? That a false guru tries to show you their way, and a true guru helps you find your own way. So similarly, a mediator who wants to do everything their way, who has one, in the United States, we would call it a cookie cutter approach. That's not good because the people are different, the cases are different. You've got to tailor the mediation to the particular people who are involved. So while a joint session may not be right in every case, it's probably helpful in a lot of cases, particularly if you structure it the way I was describing earlier with get the briefs, talk to the lawyers and the clients right when they show up, have a tailored agenda with a time limit, follow it up with a caucus. That's good mediation. I mean, that's a process that we can actually teach people. It's a set of skills that people can actually master. And of course, there's got to be variations case to case. You're not going to do things exactly the same way in every case, but understanding the basics of it gives you a point from which you can depart and improvise.
Yes, that's great. Thank you, Jeff, for that one. Now this one goes from all the mediators to you. See, what are your views on Singapore?
Shilpa ma'am, sorry to interrupt. Sorry to interrupt, Shilpa ma'am. It is
Time?
already 10:30.
Okay.
Yes,
So
but
we,
definitely your question, your
yes,
further question and the messages in the chat box, we will request
yes,
Jeff to reply. We will try and
absolutely.
send the email to him.
Thank
Yes,
you,
thank
Jeff.
you very
That
much.
was wonderful. And we had to stop. Time is a essence of every contract.
Go on a
So
long
thank
time.
you.
You would go on a long time. You guys
Yeah.
ask terrific questions, all of you, and thank you all so much for inviting me to your university, to Maharashtra National Law University in Mumbai. You obviously have a wonderful program there. Your students are benefiting tremendously and are obviously going to be the leaders of the mediation world in India and beyond. So as I've learned at the end of when we depart in India, namaste. Thank you all so much. It's wonderful
Namaste.
being here.
Thank you.
Yes.
I hand over it to Poonam.
Yes. Sir, thank you very much. This was very much excellent and interesting, knowledgeable interaction. What I learned is that we have to adopt the skill of being patient to be a very good mediator. Certainly, this event has been an enriching experience to gain more in-depth knowledge of mediation from you, sir. We are thankful to you, sir, for your valuable time and support. And I also take up this opportunity to thank Mr. Chirag Balyan, who had this idea of inviting you, and he arranged all this. And Mr. Rakshit Rana, who provided technical support throughout this event and pre-event preparation. Rakshit is also a student of MNLU, and he secured second rank as mediator in the novice mediation negotiation competition. I thank to Tanu Mehta madam for our course director of the MA mediation, and Nosha Last but not the least, on behalf of MNLU and the first batch of MA Mediation and Conflict Resolution degree program, I like to thank all the attendees for this event. Thank you, sir. Thanks to all.
Thank you.
Thank you.
So we can leave this meeting. Yes. Thank you.
Thank you very much. It was a lot of fun.
Thank you.
I hope it was what you're looking for.
Yes, thank you
Yes.
very much, Jeff. We
Sure.
enjoyed and we have lots of questions. So naturally, this is not the end. We are going to continue it.
Okay.
Jeff, there were some questions in the chat box.
There seem to be a lot of comments in the chat box.
Yes.
What do you want to do with those? Do you want to, well, how could I answer them? I don't have people's emails or, I'll tell you what, if you want to review them,